Good morning, everybody. Welcome to the Wednesday installment of the RTPI Planning Enforcement Week. Bit of a wet day. Hope you all have a cuppa to warm you up while you listen to today's session on delivering in positive outcomes. My name is Izindi Visagie, and I'm a partner in Ivy Legal, a company who does planning enforcement for local authorities. I'll be chairing today's session. But before we start, just a little bit of housekeeping. So today we have 3 presentations of about 10 to 15 minutes each with a Q&A afterwards. If you have any questions, please type them into the questions box and I'll put the questions to the panel once all the presentations are finished. If you have a burning question, I might interrupt the speakers, but I don't really want to do that. So you can see our panelists before you, but I'll introduce them one after the other. Firstly, I'll say that enforcement is sometimes perceived as a destructive and punitive force, but ultimately the point of planning enforcement is to uphold the integrity of the planning system and to mediate between often competing interests of protecting the environment, facilitating economic prosperity, and managing the impact on society. Development must be sustainable, and this is where enforcement comes in. It ensures that development is sustainable. Our speakers will give you a few examples of this. So first up today is Sarah Feist and Marcus Bayona-Martinez, both of the Vale of Glamorgan. Sarah is a principal planner in the Appeals and Enforcement team, having previously managed enforcement teams in Wales and West Sussex. Marcus joined the Vale of Glamorgan in 2017, firstly as a student planner in DM while studying towards his planning degree at Cardiff University. After graduating last summer, he took a role as a planning enforcement in the same team as Sarah and is currently studying towards his master's degree part-time. Marcus and Sarah have been actively involved in the enforcement action undertaken at Barry Waterfront, one of the Council's strategic sites, and the subject of today's presentation. So thank you, Sarah and Marcus. Please go ahead.
Sorry, there we go. Thanks, Izindi, for the introduction. So I'm Marcus, and I'll be starting our presentation today. The purpose of our presentation, there we go. The purpose of our presentation today is to guide you through the enforcement action that we took at the Barry Waterfront site, which is our largest development site at present in the Vale of Glamorgan, why we took this action, and why we believe the enforcement action resulted in positive outcomes. So for those of you that aren't familiar with the Vale of Glamorgan, why is my PowerPoint not working? This is the last thing that I wanted to happen right now. Just give me a second. I have no idea why this isn't working. Sorry. Is it working on yours, Sarah? Oh dear. Okay, I'll crack on anyway. So for those of you who aren't familiar with Barry, the waterfront is I'll crack on anyway. So outline planning permission was granted originally in 2012 for the comprehensive redevelopment of the waterfront site. The site's 430,000 square metres and is allocated for housing, commercial, office, educational and public open space. Development is ongoing at the site and it's being carried out by a consortium of 3 developers, Taylor Wimpey, Persimmon Homes and Barrett Homes, across 6 separate phases. 5 of the phases are allocated primarily to residential development. So at the centre of the waterfront is first phase, and this area is known as the district centre. And on the PowerPoint, I had a nice plan that could have showed you that. However, it doesn't because for some reason it's not working. This is identified. This area This area and its delivery is the primary reason why we have been taking enforcement action on the waterfront and why we are both talking to you today. The district centre will provide 2,000 square metres of retail floor space, 400 square metres of D1 and D2 floor space and some residential accommodation. The other 5 phases will be primarily residential, which is why the mixed use of phase 1 is considered vital. A condition attached to the outline consent in 2012 identified that the district centre should have been completed prior to the occupation of any residential units in phase 3 of the waterfront development, which is the area in the bottom left of the slide. Well, it's not here in the bottom left of the slide, but we'll move on anyway. We'll also be talking about phase 4, which is another area of the site as well. So the 2012 consent identified that the district centre had to be built prior to the occupation of any of the units at phase 3. However, the image here, so by the time that all of the units at phase 3 had been almost occupied, the district centre was quite limited in how far it had come on. In fact, off the top of my head, I think it was slabs. So yeah, this condition was breached. Whilst a lot of the occupation had taken place at phase 3 and also at phase 4, a significant amount of construction had already begun, which shouldn't have gone ahead. So our initial response to this was to take enforcement action and try to rein in the pace of the residential development and put some of the focus on delivering the district centre. By this time, the original phasing plan was completely obsolete, and that's because phase 3 had been almost completely occupied. So we need a new one of those as well. A temporary stop notice and 2 breach of condition enforcement notices were therefore served on 2 of the developers. These notices stopped further unauthorised occupations of phase 3, and these also stopped and halted construction of phase 4. We found that this action was beneficial as it brought the developers back to the negotiation table and paved the way for a second phasing plan. The second phasing plan was agreed in June 2019. And it set new triggers in relation to the build rate and the occupation of phase 4. So the second phasing plan resulted in new or slightly old issues starting again. We began monitoring compliance with it and found that whilst development on the houses at the waterfront and phase 4 was progressing at quite a rate, this wasn't being matched by the development at the district centre. So at critical stages of the phasing plan, monitoring took place almost once a week. This involved close scrutiny of the phasing plan to ensure compliance. We had to check certain houses for occupation and also their build rate. There were 2 build rate triggers, first fix and foundation stage. First fix monitoring included entering properties and checking whether bathrooms, toilets and sockets had been installed. And foundation stage was the most simple as it meant any development above DPC level. From monitoring the site, we found that by September, the developers were pushing their early triggers and had already breached them in some cases. At that time, I had some good photos that showed you a couple of buildings that shouldn't have actually been above foundation stage, but we can't quite get those up yet at the moment. All the while, progress at the district centre was quite limited and well, they hadn't got on with their trigger. Sarah's now going to talk to you and I'm now going to try and get the presentation working. Okay.
So the first trigger was the construction of the first floor transfer slab at the district centre. And this was literally a cement slab on the first floor with no exterior, and was reached in November last year. We had a slide of that. However, as Marcus has already identified, in some cases the developers had already progressed past their triggers. For example, one of the breaches was that on one of the development sites, 25 units had been constructed past foundation stage, and this included a block of flats, which we had a picture of. So as a result, we served 3 enforcement notices. The first was a temporary stop notice and stopped any further construction on the residential units past foundation stage, and also required any further occupations to cease. We did, however, exclude those residential units already occupied up to the 4th of October, which is when the temporary stop notice took effect. So as you can imagine, we were monitoring the site very closely at this stage and had to check each of the units for signs of occupation. We followed this with a breach of condition enforcement notice. This required the construction and occupation of the residential units to cease until the phasing plan build rates for the district centre were met. We then served a second temporary stop notice, which required any further construction and occupation which exceeded the restrictions set out on the phasing plan to cease. We needed to serve a second temporary stop notice, as the first temporary stop notice had ceased to have effect on the 31st of October and was designed to cover the period from when the breach of condition notice was issued to when it came effective on the 29th of November. After this, we monitored the site but found that no triggers had been breached by this developer. The second trigger that we monitored was temporary shell and core. This trigger required that the district centre had to be secure and weathertight and included the exterior shell being finished and weatherproof over the openings. And we had a slide of the district centre to show you as well. Our initial visit in mid-November last year confirmed that the external brickwork was incomplete and the structure of the units was not watertight. Whilst this trigger was not reached until late November, works on the residential units had continued. During one of the monitoring visits that we carried out during this period, we found that the external doors in some of the residential units appear to have been locked from the outside, so we were unable to gain entry, although we could clearly see the contractors working on the inside. When we did subsequently monitor the site in early December, this confirmed that on one of the sites, works on at least 13 of the residential units had been taken past the first fixed stage. Taken into account the hours of work restriction which applied to the site, this meant that the developer would have needed to have installed the kitchens, bathrooms and all of the sockets and switches in these 13 dwellings in the space of about 20 hours. It was therefore clear that some of the works had been carried out prior to the district centre trigger point being reached, and the developer was unable to prove otherwise. On another site, works on 6 of the market units had also progressed past the relevant trigger point, and as a result, 2 additional breach of condition notices were issued on 2 of the developers. So at the beginning of the year, prior to lockdown, the developers were already in a position where they were requesting more flexibility on the second phasing plan that we had agreed in June 2019. But they couldn't exceed the triggers as we had a number of enforcement notices in place. Whilst lockdown stopped work on the whole waterfront development, I think we had about 6 weeks where we weren't monitoring the site. This resulted in a further delay. It wasn't very long after the works recommenced that the developers were nearing their next trigger and further flexibility was being requested again. But whilst works on the residential elements progressed, the fact that we had a number of enforcement notices in place ensured that works also progressed on the district centre. In the post-lockdown period, there's been further discussion with the consortium developers and a further application to agree a third phasing plan with amended triggers has recently been approved. So whilst this allows the consortium developers to make further progress on their residential development, the construction and occupation on a number of dwellings has been effectively held back until such time as the A3 units on the district centre are delivered and marketed, and also the public realm works have to be complete. As the residential schemes are nearer completion, we'll again need to monitor the site very carefully and the new phasing plan. My next slide was a summary of the enforcement notices that we've issued since November 2018. So this was a temporary stop notice in November 2018, breach of condition enforcement notice in December 2018, a breach of condition notice in July 2019, and a breach of condition notice in August 2019, a temporary stop notice, a planning contravention notice, and a breach of condition enforcement notice and a further temporary stop notice in October 2019, and 2 breach of condition notices in January 2020. So in addition to requiring compliance with the phasing plan conditions, a number of the breach of condition notices also picked up on other breaches we had identified, including landscaping, means of enclosure, and hours of work. So although the monitoring and taking of enforcement action has been very time consuming, we feel that this has enabled us to deliver a number of positive outcomes. Firstly, without taking enforcement action, we would not have been able to secure continued progress on the district centre. We've maintained a good relationship with the developers overall, as the action taken has ensured that negotiations with them has continued. We feel it's also established a precedent for other applications with these developers and also other developers. We recognise that the action we've taken has had an impact on home buyers, particularly those who have been stopped from occupying their properties. However, we have made sure that all those who have been affected are aware of the reasons for the action we have taken and have engaged their support and understanding of this. So finally, and as identified by Marcus at the start of the presentation, the waterfront site is our largest strategic site under development at the moment. By taking enforcement action to progress development on the district centre, we've not only secured an attractive and sustainable mixed-use facility central to the waterfront development, but have also made a positive contribution to the strategic objectives of the LDP. So we have a new phasing plan in place and hope that the district centre will be completed by spring or early summer next year without the need for further enforcement action. And I was going to leave you with a recent photograph of the district centre, which is taken from the completed residential development of phase 4. But if you ever get the opportunity, please come to Barry and have a look at the new developments. Thank you very much for listening.
Thank you very much, Sarah and Marcus. I should tell you that the audience was actually able to see your presentation because our wonderful organizer had it up on the screen while you were talking. So they were able to see a lot of the images. Thank you, Sarah and Marcus. What a great example of being at the forefront of ensuring development is sustainable by taking swift action early on and enabling the council to negotiate from a position of strength. Often enforcement is said to be about negotiation, but ultimately negotiation is all about leverage. And if you can negotiate from a position of strength, I think you are better able to achieve a positive outcome like you have done. Great work. I'm sure I know there are a few questions already. So if you could be ready for those in the panel discussion a little bit later, please. Next up is Tom Wicks from Enforcement Services. Tom has worked in planning enforcement for over a decade and has experience in all aspects of planning enforcement, including visits, public inquiries, prosecutions, and direct action. He has qualifications in both planning and law and is an RTPI chartered planner. He's also NAPE's representative for the Southeast. Tom will be showing you today how direct action can deliver positive outcomes. Thank you, Tom. Tom, you're still on mute, so if you could please unmute yourself, thank you.
Is that better?
Yes, we can all hear you, thank you.
Good, sorry about that. Just try and get rid of this for you. Thank you. Yes, I was just saying thanks to Izindi. My background is in planning enforcement. I was a planning enforcement officer for a good few years at London authorities and some district authorities across the southeast. So I have a bit of experience in urban areas and in the countryside and dealing with lots of different issues. We're talking today about positive outcomes in the context of enforcement, but really, as Izindi alluded to, the enforcement regime is largely remedial, and so we are somewhat restricted in the type of outcomes we can deliver. That's not to say that we can't be effective and have a really positive impact on health, safety and sustainability if we do enforcement properly. Whilst we talk about a case study, I wanted to show you a few different examples that may not seem enforcement problems, but I will show you how we could deal with those. The top left is a bricked up doorway in a listed building. In that scenario, the owners of the building had applied for a planning permission to turn it into a HMO, which had been refused because there was not adequate escape. So there was only one way in and out, and that was through a barber shop. So they took it upon themselves to smash through a wall in the listed building and then apply again for planning permission for a HMO, which was again refused. The top middle is a roadside advert. I'm sure you've seen a lot of these around. Again, may not obviously be a planning enforcement issue or something that planning enforcement can deal with, but it can. On the top right is a garden in a residential neighborhood that's just been left to overgrow, filled with rubbish, and the house is in a poor state of repair. The bottom left is a shop front in a conservation area that has just been left to degrade, and the bottom middle is a high street, and that's become quite an issue at the moment with social distancing, where shopkeepers will extend their property to the front, taking up valuable pedestrian space. And on the right hand side at the bottom is a house underneath a mountain of ivy. So whilst we go through this presentation, just have a think about what you could do with planning enforcement and whether that is something that planning enforcement could deal with. In terms of what tools we have available to us, these are some of the most obvious when faced with a breach of planning control: no action, a strongly worded letter, a planning application, a conviction for non-compliance with a notice, or an injunction. But which of these actually remedy the situation, and which of these deliver a positive outcome? And I make the comparison with a different unlawful activity, stealing a car. If someone stole a car, what would be the minimum you would expect once that person's caught? To my mind, it would be that you would take the car away from them. I think that's a similar approach should be taken with planning enforcement. The first step should always be, when confronted with an unlawful development, to take away the car, or to take away the building, or to stop the use. Then once that's been achieved, you can start to think about, should we punish, should we fine someone, should we do all these other things? And of course, all the tools that I talked about earlier can lead up to that remedy, that taking away the car, that getting rid of the building, or that ceasing the use. But unless they do lead to that final conclusion, unless you achieve that remedy, then really there wasn't a lot of point in trying. You wouldn't be satisfied if the person who stole your car was convicted and fined, but was able to keep your car. So I turn now to a case study, and this is something that happens all over the country and is a particularly difficult one because of the nature of the owners of the property and the natures of the occupiers. So this was a semi-detached house in London. it had been converted unlawfully into multiple occupation, either as flats or as a HMO. It was in a horrible state, as you can see, mold growing, and they'd also erected a building in the back garden that was let out as a dwelling. The council issued an enforcement notice against the whole building, requiring the use to cease and requiring the building to be knocked down, but that notice was not complied with. The council were then faced with a number of options, but it was difficult to really pin anything on anyone because the house itself was occupied by vulnerable people who had drug problems or alcohol problems or mental health problems, and it really wasn't something that they had the capacity to deal with. And the owners of the property were registered in the British Virgin Islands. So again, finding out who they were and who was ultimately responsible and in ownership of this property was difficult. So the council decided the best course of action would be to knock the building down. Under section 178, the council entered the land, knocked the building down, and the turbulence that caused enabled them to progress the matter further. When the council do these actions, a charge is placed on the land for the cost of the works, and that enables the council to either sell the house or try and recover the money from the owner. In this case, it enabled the council to secure a restraint order, which prevented the owners, whenever they were found or identified, from selling the property. And in order to do so, they had to get various permissions from the court, etc., which meant identifying themselves. And in the end, once they had realised that this had happened and that it wasn't going to go away, they did have to identify themselves, and that enabled the council to then, following this action, prosecute them. And in total, the court imposed fines and confiscation orders of £300,000, which meant the owners had to sell the property to someone who would actually take care of it. And this was the end result. Neighbours very, very happy. The property was turned back into a single family dwelling. The garden was remodeled and redone, and the owners of the property had lost all the unlawful gains that they had made. So I'll turn back now to some of the examples I showed you earlier. And the one thing I would say is that throughout my career, especially when working in planning enforcement departments, I have found on numerous occasions that you will be told that you can't do various things, that you can't achieve what you're setting out to achieve. You can't achieve knocking down the building or remedying the harm because there's some other legal process or some other letter or some other piece of paper or notice that you need to get, and that will either come from the lawyers in the council sometimes, or from senior managers, or from even your fellow planning enforcement officers. But the thing I think is important to take away from this is that you can achieve these things. It is doable, as long as you just follow the process and use the tools that are available to you. So this is the wall. Again, not necessarily an obvious planning enforcement problem, but the tools are there. We went in, took away the offending wall and replaced it as best we could. Obviously, that photograph is of it just completed, so it does look new. It hasn't weathered in yet, but over time that will fade in. An advert. Again, probably not necessarily an obvious planning enforcement problem, but the council can issue a notice. Once that notice isn't complied with, they can go and take the advert away. The back garden can be cleared in the day and the house tidied up. Again, a shop front in a conservation area, painted, all the windows above painted. Just small things that make a big difference in an area. So you may think that that's not very significant, but when you have properties like the one on the left, all down the high street, and they're left unchecked, eventually the whole high street becomes drab and shabby. Whereas if you just start off on the first one and really take it to the end of the process by restoring it to a good standard, you will prevent the whole high street from turning into that. Shop fronts, again, how they should be, with the retractable canopies. Shopkeepers put their fruit out or whatever in the morning, put it in at night. There's no permanent obstruction to the path. And a house covered in ivy, again, not necessarily a planning enforcement problem that you would expect to see, but planning enforcement has the tools to deal with these issues and can make a real difference. Probably one of the larger buildings that I've been involved with, a care home that was spanning 4 or 5 back gardens in West London that had been built without planning permission, believe it or not. Again, planning enforcement has the tools to deal with these sorts of things. That's the end of my presentation. If you have any questions or want to see any further examples, those are just things that I thought aren't obvious planning enforcement problems, but do give you a sense of the broad nature of planning enforcement's powers and the type of things that it can deal with. There's my email address if you need it. Thank you.
Thank you very much, Tom. Great presentation. I'm also a strong believer in direct action and that it can be a very effective remedy. And the photographs clearly speak for themselves. Thanks, Tom. So our third presentation today is by Beverly Smith from Moray Council in Scotland. So Beverly has been a chartered planner since 1994, and she previously worked as a planning officer down south at Ottlesford District Council for 10 years, and before moving to Moray Council, where she's been for the last 19 years, having started out as a planning enforcement officer and moving up to manage the building standards and development management team. So Beverly has chaired the Heads of Planning DM subcommittee for the last 3 years and has a place on the Heads of Planning Executive Committee. Beverly will be talking to you today about the Scottish equivalent of untidy sites. So the way people know them in England is under Section 215 of the Town and Country Planning Act. Thanks, Beverly.
Thank you for that introduction. I'm a little scared now after the 2 presentations earlier to see whether or not you can actually hear me and see my presentation. So I'm just going to kick on. Thank you for that.
We can hear you fine. Thank you.
That's lovely.
All
so I have spent 30 years nearly in planning, and all that time in development management. So I have got quite a lot of experience dealing with enforcement. And like Tom, was a planning enforcement officer for 3 or 4 years on my own, dealing with all breaches of planning consent in a local council. So I have to say that was the most enjoyable time of my career, and I'd certainly recommend to anyone, any planner, that it is an important and integral part of planning to ensure that the integrity of the system is maintained. And you learn so much from dealing with those cases, whether it's communication skills, negotiation, and the importance of precision of drafting notices. So what I've chosen to do today is to just pick on one simple tool that we've got in our kit in Scotland, Section 179 notice, in terms of maintaining land, and just to run through a very simple case study with some lessons that we learned, and it's a little bit of a story as well. So I'll hopefully be able to move on to the next slide. So it all started back in 2006. That was the beginning of a long saga received lots of complaints about untidy state of land in a historic setting, and the value of the land around there was high quality landscape and quite an important part of our area. Like many cases, you end up with protracted negotiations to try and get the land tidied back into a state that you'd expect for this type of area. And whilst that was going on, more and more material was being brought onto the site. So we took the decision not to take an enforcement notice in terms of change of use of land for storage. We thought we'd try our amenity notice, which we've had lots of success with. So we served that on the landowner. As everybody knows, normally with enforcement cases, when you serve a notice, that normally follows up with an appeal. So we had one of those that was dismissed. And as you all probably know as well, when you get to that point, the only way really to rectify and get that breach resolved is to take direct action, and it's about following through those initial recommendations. So that's what we did. We tidied up the site. It didn't take too long, it cost us a little bit of money, but we managed to get that recovered through the courts. So we thought, right, we've cleared the site. 4 or 5 years later, the same story again. Basically get back to where we were, more complaints from people who were living around the site, refusing to cooperate from the landowner. So again, we decided we'll serve another amenity notice. It seemed to work the first time. A bit disconcerting and demoralising to think that we have to go through the whole thing again, but we did. We served the notice. We had another appeal, and we took direct action, which was successful. It was important in the amenity notice to make sure that every item that you want removing was photographed and listed. Otherwise, you are going to get yourself into trouble. So that was the middle of the story. That was 2011, and we thought, right, maybe we've got to the end of this. And then 2016, 4 or 5 years later, once again, the materials started to build up on the site, having an adverse impact on the amenity of the surrounding area, and that was what was important. And we thought, we've been through this twice now. We've served 2 notices, we've had 2 appeals, and we've taken 2 direct actions. So what are we going to do differently this time? How are we going to stop the cycle? So before we took direct action, we did serve another notice, but before we took any further direct action, I went to court. We got an interdict, which is a fairly straightforward process. I know in England it's an injunction, probably something different in Wales. The tool is there, it's not difficult to use. And by having that, when we did take direct action the 3rd time, we've made sure that we had the interdict simultaneously. And I have to say that was a success. From that day onwards, we haven't had any more material brought on the site. But we did learn a lot of lessons. It took us a long period of time to get to that point. So just really to share that with you, if you are going to go down that road, make sure that you've got a full inventory of every item that you want removing. Make sure it's listed, photographed, and attached to that notice. When you do come to actually take direct action, which is something that you will possibly have to do, make sure that you've thought about in advance where you're going to store all those items. You have to leave them in a place for at least 3 days to get the owner the opportunity to try and recover them. At that point, it is quite nervous because you think, is he just going to come and take all the items and put them back on the site? But that's part of the requirement. So if you haven't made proper arrangements, then that's a potential problem. So that's something to share with yourselves. And my advice really is, if you are going to go down that route, don't shy away from using interdicts. Obviously, it does seem, if you've not got a lot of experience with it, something that you'd like to try and avoid. But my advice is, the sooner you use it, the more effective it's going to be alongside other tools, and maybe not get into the cycle that we went to for 4 or 5 years over a substantial period of time, really. My advice really in terms of untidy land is before you go in and take action, make sure that the site itself is actually worthy of needing a notice. You know, sometimes you have success, which is good, you get lots of publicity, and then you end up with lots of other inquiries where people are saying, I live next door to somebody who's got untidy land. And yeah, that is the case of our cases where people have gardens that are untidy, unkept, but are they really having an adverse impact on a special area? And are you really confident that you've got the resources to invest into a site and really create a long-term positive outcome? So there's some of the lessons that I learned from a very long case study, and happy to take questions and share anything else with you. So thank you for listening.
Thank you, Beverly. A great example of how to clear up untidy sites, and important to think in terms of what you want to achieve, thinking about the end result. I would like to ask all the presenters to turn their video on, please, for our Q&A session, which will start now. I think through the presentation, the theme that has come out for me is that it's important to issue the notices, firstly. It sounds trite, but you need to issue the notice because that allows you to negotiate from a position of strength. And then once you have a notice and you're not getting compliance, it's important to follow through on action. So whether that's direct action or otherwise. And it's very interesting that Beverly mentioned the interdict or injunction option in conjunction with an untidy site, because that's not a common. It's not two actions that usually go together. Certainly, injunctions tend to be reserved for gypsy and traveller sites, frankly, but clearly they are appropriate for other cases as well. And it's very interesting to see how they've used interdict with an untidy site notice, and like I say, interdict would be injunction in England.
Could I just make, whilst we're on that subject with Beverly, I just thought I'd make a quick observation, if that's okay.
Yes, of course, please go ahead.
Beverly, because you experienced this problem multiple times, and you'd served the amenity notice. You have to serve that over and over again. But one thing that we do quite often is, alongside the amenity notice, serve a enforcement notice as well, alleging a change of use to the storage of waste, for example, which remains in perpetuity. So you would not need to keep issuing another notice every time he brought more waste onto the site, for example, and it would enable you to thereafter go for a prosecution for the time period when you served the original enforcement notice. It's just another way, another thing alongside your injunction, your direct action of ensuring the site stays clear forever, and that you can't just remove all the waste.
Tom, depends on the individual case, and I think this was a site where it wasn't an immediate storage issue, and it wasn't going to be easy to identify a material change of use because of the history of the site. So I think what's important here is that it's this length of time with material coming on, and it's not that it took us a long time to do and that we didn't consider other options. We could have easily have done that, but during that period of time there's a lot of negotiation and changing circumstances. We've got hundreds of pictures which really aren't reflected on what I've demonstrated today of the material that came on, and some of the unusual items as well. So it was quite a unique case, and yes, it's quite easy to serve a notice and say that's in perpetuity, but that wasn't what we deemed to be appropriate in this case, simply because of the unique circumstances and the transient nature of items that were being brought on and off the site. So it is about picking your case, but yeah, thanks for that.
And Beverly, while we're talking about this, I think it's a lot of questions about your site, but one attendee is asked, he said, thinking about positive outcomes, could you talk a little bit more about the landowner's rationale for the untidy use of the land, and what kind of materials you found on site, and whether we can be confident that the materials are now being stored by the landowner elsewhere in a responsible way? Do you know?
It's an interesting question. I think a lot of it is down to individual nature, whether people decide to hoard things on site for whatever personal reasons, and it is a unique case. But I think the material varied from at one point a double-decker bus to cars, to carpets, to anything that anybody else didn't really want. So it was a very diverse nature, and the list of things on all 3 amenity notices changed over time quite significantly depending on what was available. No, they're not being stored anywhere else because this is one site that's been stopped in terms of that. So it's not like he's got a need to store it anywhere else. So hope that answers the question.
Yeah, thank you. And following on from that question, somebody wants to know how you judged the effect on amenity, pointing out that this is very subjective.
Yeah, that's an interesting point, and I think that's where, if you go to the DPA website, there's a list of the enforcement appeals for this site, so you'll be able to see how that's judged by a reporter. And I think what was important here was the surrounding landscape, the numbers, maybe not the numbers of complainants, but obviously the high profile site that it was. We'd spent a lot of time, money on a flood scheme which brought the land to a very high quality, and the rest of the land surrounding the area, with the historic buildings as well, was deemed to be an important site. And I think it is about putting that value in terms of amenity. So it's quite easy for somebody, for an individual, to say it's affecting their amenity, but it's about having a wider amenity impact on an area of importance to a local council, and how that's impacting on the surrounding landscape as well. So it is probably the key to winning an appeal. But it's not just about neighbours complaining, it's actually about trying to assess and judge how that site used to look before any material was coming onto the site. So I think having a before and after is quite important.
Thank you, very useful, and also interesting to see the difference between the Scottish system and the English, because your appeal had to go to a recorder, which is a planning inspector in England, and in England, of course, untidy site notices are appealed to the magistrates court, which is a very different kettle of fish. I'd like to just go back to Marcus and Sarah, if that's okay, because we have a few questions for them. So one person asked, I believe you couldn't issue more than one temporary stop notice. And I noticed from your presentation, Marcus and Sarah, that you had issued a number of temporary stop notices. Were these in terms of different aspects of the development?
No, we issued a temporary stop notice on the same developer. You can, under section 171F of the Town and Country Planning Act, enables you to issue a further temporary stop notice if you have taken another form of enforcement action on the site. So in this case, we served a first temporary stop notice. We then served a planning contravention notice to get some information. We followed that up with a breach of condition enforcement notice. And once that breach of condition enforcement notice had been issued, we could then follow that up with a temporary stop notice. So that sort of plugged the gap between when we'd issued the notice and when it became effective. So it just meant that the developer couldn't carry on the activity. So there is provision in the Act to do that.
Okay, thank you.
Just to add to that, sorry. So we went and we found initially that there were a few breaches. So, sorry, did you hear that? We found there were a few breaches initially. So we thought we needed the time, which is offered by the temporary stop notice. So that's why we went with that option initially. And then, as Sarah said, after establishing what the breaches were, we went down the breach of condition enforcement notice route. And then during the 30-day or 28-day compliance period, that's when we served another temporary stop notice, just to bridge the gap. So they didn't carry on in breach until we had an enforcement notice active on the site. So that's breaking it down how it worked.
Okay.
That makes sense.
And have you considered any further action following on from the notices? Have the notices you've issued been breached?
We're also monitoring the site very closely, and there has, as I mentioned in the presentation, has been continuing negotiation with the developers And obviously we try to deal with all of the breaches by serving further notices. We've now got to a stage where very recently we've agreed a third phasing plan. So that's the phasing plan that we're now going to be monitoring, and we're hoping that we won't need to issue further notices on the developers. But you know, we're hoping that the district centre will be completed by next year, and then you know, hopefully we won't need to repeat the exercise again.
Okay, because somebody's asked about the specifics of working with a developer. So can you offer any suggestions there on working with this specific developer who has clearly breached a number of conditions already?
Yeah, so the main thing really was just developing a good working relationship with the developer. So we were in quite close contact with them at the priority parts of the phasing plan. We visited the district centre with all three developers, representatives of all three, at the different stages, making sure that they'd achieved them. And then we followed that up with a visit to each of the individual sites. It was just contact hours, essentially, I think, that got us into this position. They knew that either myself or Sarah would be down there at least once every week. So really, if they were going to breach it, they'd be taking a decision to receive enforcement action, essentially, because they knew that the second that they did breach, we'd be aware of it, not the second, but pretty soon after, we'd be aware of it, and then we'd follow that up with enforcement action, which I think setting a precedent of doing that was quite important. And since the start of the year, I think it's basically resulted in no further breaches. So nothing else for us to take enforcement action on, essentially, at the site, because they just knew that if something did happen in breach of a condition, they were doing it in the knowledge that they'd be served with a notice and the repercussions that can result from that. I'd also say that having good contact with the site managers was quite important. We regularly, I'm on first name terms with a lot of them, on a professional basis, of course, but it's, yeah, I know them, they know me, I know what I'm doing there, they know what I'm doing there. And I think that's quite important as well, just having those working relationships that they understand where we're coming from and why we're doing it, so that it works as a means to an end and results in them complying, essentially. Okay.
Thank you. Tom, there are a few questions for you as well. Sorry, I'm just going to... Sarah or Marcus, could you maybe mute yourself? There we go, that's better. Tom, in one of your examples, you describe taking action against an HMO. Could you tell us, was that action coordinated with social services to ensure the occupants were rehoused? And there was also another question about the vulnerable tenants.
Yeah, the tenants would be put in touch with the council's housing team, who would do their best to try and rehouse them or find them alternative accommodation. So in terms of the direct action that we took there, that wasn't inside the main house. That was the outbuilding at the back. But the housing services of the council are always made aware that there's a potential for these people might need alternative accommodation. And as part of our action, just in case there is any unexpected people inside, that we always reserve hotel rooms or whatever and try and find alternative accommodation for the occupants. They're usually very, very grateful, because as you could see from the pictures, they're living in pretty horrible conditions. They've got no recourse to the landowner of the property, and a lot of the time they just haven't got the capacity to deal with it themselves. So they are usually very grateful for the help.
Okay, thank you, Tom. Another question on direct action. Have you ever experienced, I know you have, a situation where occupiers have been obstructive in allowing access to land and to carry out the necessary steps? And if so, what tools of persuasion are most effective in gaining access to complete the remedial works?
certainly in my experience in doing it for probably 10 or so years now, is that most people go through a regular sort of timeline of reactions to that. As soon as you arrive, they shout at you and say you're not doing it, and then you say, well, I am doing it, and then they say, well, you're not, and then they say, well, I am. And most of the time, after you just start doing it, literally knocking down the thing or doing whatever, they realise, oh, actually, it is going to happen today. I can't just shout at someone and they'll go away, and they end up helping you in the end. You know, if it's up to them. If they're there and they've got valuable items that they want to keep, etc., then they will always try and help you and try and remove those things themselves rather than you doing it, because you're not going to be as careful as they would be. But also, if you do anticipate that there's something that you potentially couldn't deal with, i.e. someone was mentally unwell or there were weapons or something, you can always take the police with you if you need to, because it is an offence to obstruct the council in their exercising their 178 powers, or even just their 196 powers, just visiting the site and looking at the land. So it is an offence to obstruct you.
Okay.
But
I was just going to come in there, Tom, and say that in my experience, it is very important, if you're going to take direct action, that you know who you're dealing with before you get whoever you've arranged to go and remove that equipment on site to protect their health and safety. So, you know, I've had sites where I've had to contact the police and make sure that they're aware of potential harassment and threats that have been made for us to do this, so that they're lined up ready on call to come in. Because I mean, the most important thing, apart from getting the direct action carried out swiftly and timorously, is to make sure that the people who are doing that are safe, and if at any point they're not, then that action stops, and then you come back another time. So it's all about preparation and make sure that you know who you're dealing with and when you're going to do it in terms of timing. So generally speaking, my advice to anyone is, you know, have it all set up the night before, everyone briefed, and then go in early in the morning and do it as quickly as you can and make sure that your staff are safe. That's what's really important.
Certainly in our experience, we've probably done hundreds of these direct actions now, and there has never been an occasion where we haven't been able to complete the work on the day we'd said we'd complete the work. We, like Beverly says, we make the police aware that we're going. We don't necessarily take them with us. We just open up a reference, more to avoid any confusion, because a lot of the time the occupants of the land or whatever will make claims that you're breaking in and you're trying to rob them or whatever, and they'll phone the police and tell them that they've got 15 men there that are trying to break into their house, etc. And the police will say, well, yes, we know they're there. They've opened up this reference. They've told us about the work, and they're not breaking into your house. They're just complying with the notice. So there's no need for it. And we have had people prosecuted for making for lying to the police about being broken into before. But like I say, we've probably done over at least 200 or 300 direct actions over the last 10 years, and we've never had a time when we couldn't complete the work on the day we arrived.
Thanks, Tom. Sorry, we're out of time actually, but I just want to ask one question, because there was a question about the role of enforcement officers, particularly in looking at planning applications. If the aim is to deliver a positive outcome, one person asked, does the enforcement officer get involved in the planning application? Because this particular person says enforcement tends to take a back seat, and the main focus is on DM, on determining applications. And I wonder, Sarah and Marcus, whether you could comment on that.
Yes, at the Vale, quite often if an application or a case comes in, an application comes in as a result of a case that we've been dealing with, one of my team will pick up and deal with the application. That doesn't always happen, but if they've been heavily involved in the case, then it makes sense for them to deal with the planning application. So that sometimes happens, and that's quite helpful in ensuring that there's a consistent approach to the case.
Yeah, that's quite good. I think there seems to be increasingly more of an overlap between enforcement and planning, which is a good thing. Marcus, did you want to say? Yes, please.
Yeah, I find that in a lot of situations you get, so in a lot of situations we take on the ones where there's quite a complex situation, and that it's probably best if the enforcement officer is the one who takes on the application, and that's because we've got the knowledge of who the person is and what they're looking to do and the site in general. Whereas if an applications officer comes in straight away to that situation, they might not be best positioned without a good briefing from us to deal with it. So in a lot of cases, it just saves a lot of time in getting to know a certain context and site to just get the enforcement officer to deal with the case. Or anyway, that's what we found here a couple of times, and that's generally when Sarah asks us enforcement officers to take on those cases. Okay.
Great. Thank you. Thanks very much. I'm conscious there are still a few questions because I think everybody's really interested in all of your presentations, but we're going to have to cut it short. Thank you very much to all the presenters and everyone who attended. Hope you enjoyed today and enjoy the rest of the enforcement week. Thank you all. You could just log out now.
Bye.
Right.
Thanks.